All right, so good afternoon, evening. Thanks to you who is joining live. I appreciate it, and to those who are watching the recording, I appreciate it as well. Welcome to our workshop on holding government accountable. This is a workshop series that's focused on how individuals inside and outside of government hold it accountable to the Constitution, federal and state laws and regulations. This is a series of 16 30-minute workshops, and we hold them every Wednesday from 7:30 to 8 via Zoom. So we have covered a very broad range of topics on the concept of holding government accountable, from things like local level politics to state level politics to national level politics. And what we're doing these last few weeks is talking about how you hold specific levels, and in this case, past couple of weeks, talking about the court system at the state level and at the federal level. So today we're going to talk about holding the federal courts accountable. So we'll go ahead and jump to that. So by the end of this workshop, you'll be able to do the following. First is explain the structure of the U.S. federal court system. Secondly is explain the demographics of federal judges and justices. Describe how voters weigh in on the selection of judges and justices. Describe recent examples of both congressional oversight of the courts and of public protest of the courts. So this is a map, or a map, a chart. And let me just double check here. So this is a visual representation of the federal court system. I'm going to highlight a couple of things here with my pen. First is at the highest levels of government, we have our Supreme Court. And at the next level, we have the U.S. Court of Appeals, the U.S. Court of Appeals for the Federal Circuit, and the U.S. Court of Appeals for the Armed Forces. Below the U.S. Court of Appeals, we have, note that we have 12 of them around the country. And within those 12 geographic circuits, we have U.S. district courts, and there are 94 of them total. And we also have a U.S. tax court. That, any cases from there that are appealed will go directly to an appeals court, just as it would for a U.S. district court. For the U.S. Court of Appeals for the Federal Circuit, there's the U.S. Court of International Trade, the U.S. Court of Federal Claims, and the U.S. Court of Veterans Appeals that send cases to this particular appellate court. And then lastly, we have a Court of Criminal Appeals for each branch of the military, and then any court martials from the military itself that could go up to the U.S. Court of Appeals for the Armed Forces, and maybe even potentially to the U.S. Supreme Court. So the key here is to denote the difference between trial courts and appeals courts. And you might be asking, okay, what's the difference? A trial court is where a case gets started between a plaintiff and a defendant, or a petitioner and a respondent later in the appeals courts. But the trial courts is where, like, the first stop in the judicial system for almost every case, except special cases that are either between states or between the states and the federal government. So those cases are those courts are the beginning, and then they'll go to a specific court of appeal depending on the jurisdiction. And they could all end up in some way at the Supreme Court if there's questions of constitutionality or of determining disputes in constitutionality. So that's our U.S. federal court system. It's very broad, very diverse, very comprehensive. Now, this is a geographic representation of those Court of Appeal boundaries. So, for example, the Ninth Circuit Court of Appeals is here in yellow. So all of these states like Montana, Idaho, Oregon, Washington, California, Nevada, Arizona, Alaska, Guam, Hawaii, and Northern Mariana Islands are all within the Ninth Circuit Court of Appeals. We also have the 5th, the 11th, the 1st, and so on. So any cases that, say, for example, start in Montana and go to the District Court of Montana, they could be appealed to the appeals court located in San Francisco, and eventually they could jump over to DC for the Supreme Court. So this gives you a visual representation that essentially there are 11 different regions of the state that in theory could have, for some period of time, differing interpretations of the same, say, federal law, for example, or the the laws that are decided in, say, West Virginia, Virginia, they might kind of hold for that area. But if there's a discrepancy with how the federal appeals court in the 4th district interprets a federal law compared to, let's say, the 10th district that covers Wyoming, Colorado, New Mexico, Kansas, Oklahoma, and Utah, then eventually a case would probably reach the Supreme Court for it to say, okay, well, the 4th Circuit Court of Appeals has one interpretation, the 10th Circuit Court of Appeals has an interpretation, there's a split, and the U.S. Supreme Court needs to reconcile that split. So this geography does matter in both where cases start in the district courts and then where they go to an appeals court and then eventually to a Supreme Court. Now, in addition to the courts themselves and what we're typically used to understanding the courts to be is where a place people go to settle disputes, is knowing that there's actually a policy-making body and an administrative body of the courts itself. So the Judicial Conference of the United States is the national policy-making body for the federal judiciary. The Chief Justice is the presiding officer, and in 2019, the conference met in March 12th and September 17th at the Supreme Court in in Washington, D.C. They have a range of committees that they help to develop policy and manage their internal affairs. So things like audits and administrative office of accountability, administration of bankruptcy system, the federal state jurisdiction, criminal law, IT, rules of practice and procedure, and then advisory committees on different types of rules like criminal, appellate, and civil. So when I was in community college and later in university, I never learned that there was like this whole judicial conference that helped manage the internal affairs and set policy for the entire judiciary. I always kind of just assumed that the Congress oversees them and structures them, and that's basically it. But I didn't know that there was like this real robust governance system in the judicial courts. But for our purposes, it's helpful to know that they have at least some kind of internal mechanisms in place to manage and govern their affairs and presumably hold itself accountable to itself. Now, in addition to the structure or to the structure, the geographic dispersion, and the internal organization of the courts, we also have diversity of the courts based on race, women of color, and those who identify as LGBTQ. So this is a figure from the Center for American Progress, and this is showing or comparing sitting district and circuit court judges to active district and circuit court judges, and what percentage within each of the circuits. So we have the 1st, 2nd, 3rd, 4th, 5th, and so on, all the way to the DC circuit and the federal circuit. Now, what percentage of those judges are people of color, are women of color, and identify as LGBTQ. So for example, in the 1st circuit, which to recall is this area here, northeast US, so Maine, New Hampshire, Massachusetts, and Rhode Island. They have, we'll look at active judges, 31% people of color, 34% women, 60% women of color, and no one who is openly identifying as LGBTQ. We can compare that to, say, the 9th Circuit, where California is located, where we see that there's 37% people of color, 34% women, 30% women of color, and then 2% who identify as LGBTQ. So we can see across the circuits that they're not uniform, right? That some circuits have a higher percentage and some circuits have a lower percentage of, let's say, people of color or women. So for example, looking across the women column, the circuit with the most or the highest percentage of women is the 2nd Circuit. And you might be asking, oh, which circuit's that? What's the geography? In that case, it's Vermont, New York, Connecticut. And say we're interested in the circuit that has the least number of women. So I see a 27% seems low, 24. So 24, so our 8th Circuit. And I might be asking, oh, what's the 8th Circuit? In that case, it's the Dakotas, Minnesota, Iowa, Nebraska, Missouri, and Arkansas. So this 8th Circuit has the least percentage of women, while the 2nd Circuit has the highest percentage of women serving as federal judges at either the district level or at the appellate level. So this just gives you a sense of the kind of that makeup. In addition, we also have judges by race and ethnicity over time. So this is a chart from the Federal Judiciary Center, which is a major repository judicial data on things like meeting places, districts, seats, courthouses, and other historical information. So we see here on the y-axis or the vertical axis the number of judges. So I'll just put pound J, and then here is time in years, or actually decades. And what we see here is like, we only had about less than 200 judges up until about 1930. And the composition of them were almost all, looks like, identify as white or Caucasian. And then we start to see around 1950, 1960, the first African-American judges. At that point, we're almost at around 300 judges. And what we've seen, let's say in the next 50 years, so from 1950 to 1990, just a very large increase in the number of judges. So we went from 300, and then 50 years later, we are at about 1,000. And then we start to see that there's more African-American judges, there are more Hispanic judges, seems to be a slight number of Asian-American judges. And so we're seeing not only a growth in the number of judges, but we're also seeing an increase in the diversity, racial ethnic diversity of judges over time. So this kind of gives you like an overview of the courts, from this top level abstract organizational structure to its internal operations to its composition of its judges. So a big question that's asked is like, so here in the United States at the federal level, how do voters weigh in on the selection of judges and justices? And there's two-part answer. The first one is directly, we don't. We don't vote for federal judges. We don't vote for district judges. We don't vote for appellate judges. We don't vote for Supreme Court justices. And we don't obviously vote for those other appellate court systems as well. So we don't have a direct mechanism by which we weigh in on the selection of judges or on the retention of judges, which means keeping them in their seats after some period of time. Like we have here in California, the governor and the state senate and the judicial council will appoint people to the state Supreme Court here in California. And then after a 12-year term, a question is put before the voters, you and I and others, is asking, do we want to keep this person in their seat for another 12 years? That's a retention election. We don't have something similar at the federal level. But indirectly, we do have a say in the selection of judges, first through voting for president, because the president is the person who gets to nominate people to the federal bench at the district, appellate, and Supreme Court level. And also our U.S. senators, because the Senate is the body that has to give advice and consent to the president's nominees. And they'll be the ones who hold hearings, ask questions in public, and then vote either for or not for or against somebody who's been nominated by the president for a federal judgeship. So when we think about holding the federal courts accountable, it might be like, well, if we can't vote for them, I guess we can't. But the reality is that in our system of government, it's a little more complex. And we have other mechanisms by which we can try to hold the federal courts accountable, either through the elected president or through our US senators. Now, it isn't just up to us as the people to hold the courts accountable. It's also up to the Congress. So the Congress, because the Congress created the court system after the Supreme Court, so the Congress has passed laws over the past 200 years, and they've been signed into law by the president at the time, that have set the number of Supreme Court justices, have created the appellate court system, have determined the district court system. And the Congress decides, even at the district court system, what the geographic portion of the district looks like, where they can meet, how many judgeships they have, and even the courthouses and where they're built. And you might be asking, well, Dr. Franco, you seem to have a lot of knowledge about this. I said, yes, because this is what I wrote my PhD dissertation on. The title of my dissertation was called the Judicial Pork, the Congressional Allocation of District Seats, Meeting Places, and Courthouses to the U.S. District Courts. And I'll go ahead and have this abstract play so you kind of just get a sense of what my dissertation, my book-length dissertation was about. So I'm going to have this read to us.
How does Congress structure the judiciary, specifically the organization of the lower district courts? Since 1789, Congress has allocated at least 84 judicial districts, 686 judicial seats, 533 judicial meeting places, and 604 judicial courthouses to the lower courts. While previous scholarship has examined instances when district court seats are created, we still know very little about the structuring of the district courts by Congress. By combining insights from both the judicial politics and distributive politics literatures, I argue that Congress allocates districts, seats, meeting places, and courthouses as a means of providing pork to member states. I develop a theory of the allocation of judicial pork where I argue that Congress allocates judicial institutions similarly to traditional pork, like bridges and highways. Specifically, I contend that states with representation on the judiciary committees in the Senate and House of Representatives are more likely to be allocated judicial pork than states without such representation. Using newly collected data gathered from the Federal Judiciary Center, I test my theory using observational data from 1813 to 2014 and 4 case studies. In line with my expectations, I find evidence that suggests rank-and-file representation on the Senate and House Judiciary Committees positively affects the allocation of judicial pork.
So I have pretty healthy understanding of how the Congress shapes the courts, right? But when we're thinking about holding it accountable, it isn't just about the shaping of it. It's also about what's Congress doing now to oversee it. So I'm going to go ahead and pull up this article here that was published in Reuters, titled "Congress Approves Tougher Financial Disclosure Rules for U.S. Judges." This was a couple weeks ago. So I'm going to ahead and have, say not all of this, I'm going to say most of it will be read. Or half of it, I would say, right here. I'm going to go ahead and change the voice options. I've been kind of sticking with that voice option for a while, but I'm going to change it up a bit.
Washington, 27th April, Reuters, legislation that would subject U.S. Supreme Court justices and federal judges to tougher disclosure requirements for their financial holdings and stock trades passed the House of Representatives on Wednesday in a rare show of bipartisanship. The bill, approved on a voice vote after winning Senate passage in February, would make it easier for the public to see if a member of the federal judiciary has a financial conflict of interest warranting recusal from hearing a case. The Courthouse Ethics and Transparency Act now goes to President Joe Biden to sign into law. White House spokesperson Andrew Bates said that while he had yet to talk to Biden about the bill, he has always been full-throated about furthering ethics and transparency in government and restoring trust in institutions, and this kind of policy is aligned with those goals. Lawmakers introduced the legislation in October after the Wall Street Journal reported that more than 130 federal judges had failed to recuse themselves from cases involving companies in which they or their family members own stock.
So this article goes on to describe, the rationale behind the introduction of this bill, its passage in the House, and then, getting quotes from various political leaders like chairman of the House Judiciary Committee about like why they did what they're doing and why it's important for the broader public to know that Congress is taking action on, in this case, increasing the requirements or changing the methods by which judges can either hear a case or not. And this is a very clear example of the Congress holding the courts accountable on behalf of the public, because in this case, you heard at that last part where they mentioned the Wall Street Journal, which is a newspaper/media outlet, and they did an extensive set of reports, I think 2 to 4 different kind of exposés about all these federal judges who are hearing cases, whether they own stock or their family members own stock. And the idea is like, if they even own one stock of a company or their family members own a single stock, it's not so, it's the appearance of the conflict of an interest and a potential actual conflict of interest that the courts need to be concerned about. And so when you have a judge who says owns Apple and then is hearing a case about a piece of the device in the iPhone of Apple, and they're ruling in favor or against Apple, that can be viewed as a conflict of interest because they have a financial interest in the growth and in the expansion of that of the Apple company. And so they shouldn't be able to hear cases. They should say, I can't hear this case because I actually own stock, and this could be seen as, or it is, a conflict of interest. So the Wall Street Journal, this media outlet, did all these reports. We were like, whoa, like it's not like one or three judges. They're talking about hundreds, or at least over 100 judges who had some kind of conflict, either direct or indirect, and saying, this ain't right. We got to do something about it. So that's one example of how the Congress holds it accountable. In addition, there's also now kind of these broader concerns about judicial ethics. This kind of predates the leak that we'll talk about in another moment. But in this case, it says here, Democrats says judicial ethics problems are bigger than a single justice, in this case, Clarence Thomas. So I'm gonna go ahead and have these first few, or this first couple paragraphs read to us.
Rep. Hank Johnson, DGA, said during a Wednesday hearing on a possible Supreme Court code of ethics that he was alarmed by Justice Clarence Thomas not recusing himself from certain decisions given his wife's controversial text messages, but said judicial ethics problems extended well beyond the justice. Johnson, chairman of the House Judiciary Courts Subcommittee, said it was disturbingly clear that, without explicit enforceable rules, certain members of the High Court are going to try to keep trying to get away with more and more until they have gotten away with our whole republic. I'm alarmed, for example, about unanswered questions about Justice Thomas' failure to recuse from a decision that we now know might have implicated the actions of his wife and her apparent efforts to overturn the 2020 election, he added, referencing Ginny Thomas' texts to then White House Chief of Staff Mark Meadows about the 2020 presidential election and 6 January 2021 attack on the Capitol.
So this article goes on to describe Chairman Johnson's kind of logic behind why there needs to be a broader judicial ethics bill brought before the Congress and presumably passed by the Congress and signed into law by the president. And he's citing a case or an issue where one of the Supreme Court justices, his wife, is very involved in electoral politics, and there's documentation showing that she was calling for, the post-election turnover of the 2020 election. And so this generated a lot of controversy because, well, wait a minute, a sitting justice has a spouse who's actively engaged in electoral politics, and there's these messages calling for functionally redoing or overturning those results. And that it gives the appearance of a conflict of interest. And so this is a concern that's been raised, and it's been building. So we'll see where it goes from here. But this is yet another example where the Congress is thinking of and trying to hold the courts accountable in this vein. Now, lastly, we have, protesting the courts. Like any other political institution in the country, whether they're federal, state, or local, people have a First Amendment right of free speech, of protesting their government, of petitioning their government. Now, what's happened in the past 10 days, almost 2 weeks now, is the expectation, given a leaked Supreme Court opinion draft, that the Supreme Court appears poised to overturn a 50-year precedent about abortion rights in this country. Now, irrespective of our views on abortion and abortion rights, the idea is that this information is now public, and people have very strong and visceral reactions to it. On some arguing that abortion should be outlawed in this country, which is what overturning this 50-year precedent would do. Others are arguing that this precedent people have built their lives around this presumption, behind this judicial decision, behind the rights that it's afforded women, and they're opposed to its overturning. And now we're at a place where they can go and talk to the U.S. senators, they can go and write the president, but people are reacting in a way where they're like, we're going to protest the courts. And so shortly after that leaked opinion was made public, it says here, titled, demonstrators gather at the Supreme Court's doorstep after Roe v. Wade. So people went out in front of the Supreme Court with signs, with microphones, with drums, with their voice, actively protesting what they think is going to be a final decision by the Supreme Court. Now, in addition to that, we've had now these courts kind of getting what they call closer to home, is people are now protesting in the neighborhoods where the Supreme Court justices live. And this is generating kind of some back and forth, at least that's being reported in the media. Like, all right, some people are like, I get why you're protesting them, but at their house, really? I mean, like, they're judges. And others are saying, well, this is such a dire situation that we have to use every public mean through our First Amendment to protest. And if it's walking down a public sidewalk with a sign that is in front of their house, and that's part of this whole trying to hold the courts accountable process. So the debates, say, still ongoing about this tactic, but the broader concern, right, is that, and the broader reflection is that people are protesting directly the courts, and potential action they might take. Now, just so we point out that people have protested in front of the Supreme Court before. It didn't take this very potentially dramatic turnover of a precedent for people to do that. People gather outside this front of the Supreme Court during the hearing season, during the decision season, to express their voice, to express their concern. And just note, geographically, this is right across the street from the Congress. So it's not like a far step to like protest the Congress and then come and protest the court for the public. So all that's to say that holding the federal courts accountable, we don't do it directly towards the judges, but we do it indirectly with the president and the Senate. And now, because of the degree or the salience of some of the decisions that the Supreme Court is going to be making in the next few months, people are kind of going to the streets. And this is all to say that holding the federal courts accountable isn't out of reach for any one individual, but it certainly requires some nuance and some appreciation that the courts in and of themselves are thought to be and strive to be independent, right? But we understand that's what's gone on over the past few decades now, is this politicization of the courts, right? Turning the courts into just another branch of the political, as opposed to it being its own, rooted in law and in judicial reasoning. So all in all, hopefully this is illuminating to kind of see this and how it works. And we'll see where things go in holding the federal courts accountable, both at the congressional level and at the public level. So with that, thanks for taking the time to listen in, and have a great evening.